Fair Housing and Reasonable Accommodations Training, presented by Shirley McMillan, SMAC Consultants. Learning Objectives. This section will review the basic requirements of the federal and state Fair Housing Acts and will delve into reasonable accommodations that must be made for service and assistance animals. By the end of this section, you should be able to explain the purpose of fair housing laws, list the 7 protected classes in the Federal Fair Housing Act, define handicapping conditions, define reasonable accommodation, differentiate between service and assistance animals. Explain the complaint process, explain why automatic disqualifiers such as housing vouchers should not be used in tenant screening. For discussion, Betty hires Ray, a broker, to assist her with locating a tenant for her basement apartment. Betty informs Ray that the tenant is not allowed to have a pet. Ray places an advertisement on social media and indicates that pets are not allowed for this rental. Ray receives an application from an individual with a service animal and reviews it with Betty. Even though the prospective tenant meets all the qualification requirements, Betty tells Ray she will not rent the apartment to the tenant because of the animal. Ray informs Betty that she is in violation of the Fair Housing Act and state fair housing laws. Is Ray correct? Why or why not? John owns a residential house and decides to use it as rental property. In his advertisement, John notes that no pets will be allowed on the property. He receives several applications and evaluates each based on employment, creditworthiness, and criminal history. He selects a tenant and notifies the individual that the application was approved. 1 week after signing the lease agreement, the new tenant emails John and asks for an accommodation for his assistance animal, a pig. John denies the request, stating that 1. The pig is not domesticated and may damage the property, and 2. The tenant did not request the accommodation prior to signing the lease. Can John legally deny the accommodation request because it was submitted after the application? Explain the differences between service and assistance animals. Terminology. Assistance animal. The Fair Housing Act provides guidelines for tenants to have assistance animals in order to use and occupy a dwelling. An assistance animal works, performs tasks, provides assistance, or provides emotional support for a person with a physical or mental impairment that substantially limits at least one major life activity or bodily function. An example of an assistance animal is a miniature horse, cat, monkey, etc. Disparate impact, a doctrine, policy, or practice that seems neutral on its face, but has the effect of disproportionately harming people of a certain protected class. Major life activity, seeing, hearing, walking, breathing, performing manual tasks, caring for oneself, learning, speaking, or working. Reasonable accommodation, a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with a disability to have equal opportunity to use and enjoy a dwelling, including public and common use spaces. Service animal. The American with Disabilities Act provides guidelines for places of public accommodations to allow the admittance of a service animal for individuals with a disability. According to the American with Disabilities Act, a service animal is any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or mental disability. A miniature horse is no longer considered a service animal. Purpose and history of the Fair Housing Act. The purpose of the Federal Fair Housing Act, hereafter known as FHA, is to ensure that members of protected classes have equal access to housing. What are protected classes? The first U.S. law enacted to provide citizens with equal access to housing was the Civil Rights Act of 1866. The act dictated, "Citizens of every race and color, without regard to any previous condition of slavery or involuntary servitude, shall have the same right in every state and territory in the United States to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefits of all laws and proceedings for the security of persons and property as is enjoyed by white citizens." What are protected classes? The Federal Civil Rights Act of 1866, which prevents racial discrimination in the sale of and rental of housing, is still in place today. However, additional laws have since been enacted to expand the protections to other groups of individuals. Title VIII of the Civil Rights Act of 1968, also known as the Fair Housing Act of 1968, prohibited discrimination in the sale, rental, and financing of housing based on race, religion, and national origin. In 1974, sex was added as a protected class, and familial status and disability were added in 1988. Consequently, there are now 7 protected classes expressly listed under the Fair Housing Act as follows: race, color, religion, sex, handicapping conditions or disability, familial status, national origin. Acronym: Fresh Corn. Familial status, race, equal, sex, handicapped, color, opportunity, religion, national origin. North Carolina General Statute 41A, hereafter known as State Fair Housing Act, includes protections for the same 7 classes. Also, brokers should be aware that 5 jurisdictions in North Carolina have local fair housing ordinances certified by HUD as substantially equivalent to federal FHA. Those 5 jurisdictions are the City of Durham, the City of Greensboro, the City of Winston-Salem, Orange County, and the City of Charlotte-Mecklenburg County. These jurisdictions receive federal funding under the Fair Housing Assistance Program to investigate and attempt to resolve complaints within their area. However, only one of the substantially equivalent local ordinances including additional protected classes. The Orange County, North Carolina Local Fair Housing Ordinance also makes it unlawful to discriminate in housing because of age and veteran status. The most recent changes in FHA are related to sexual preference and orientation. Lesbian, gay, bisexual, or transgender LGBT persons are not expressly listed as protected classes under FHA or the State Fair Housing Act. However, the Department of Housing and Urban Development, hereafter known as HUD, has regulations that implement policies to ensure that its core programs are open to all eligible individuals and families regardless of sexual orientation, gender identity, or marital status. Persons who identify as LGBT and who believe they have experienced housing discrimination may be able to file a claim based on the Fair Housing Act, HUD's Equal Access Rule, state and local anti-discrimination laws. Due to HUD's expanding policy for fair housing to all eligible families and individuals regardless of sexual orientation, gender identity, or marital status, brokers should realize that discrimination in housing based upon LGBT considerations may violate FHA. Protected class, handicapping condition, disability. 60% of all FHA complaints are related to the denial of reasonable accommodations and disability access. Also, most HUD charges of discrimination against a housing provider involve the denial of reasonable accommodations to a person who has a physical or mental disability that the housing provider cannot readily observe. The State of Fair Housing in North Carolina 2019 report found that in 2018, the most common complaint allegations filed were discrimination based upon a disability. Complaints alleging discrimination due to disability accounted for 59.7%, 92 out of 154 of the total number of complaints filed. In addition, 2/3 of the complaints were filed in the 5 following counties: Durham, Forsyth, Guilford, Mecklenburg, Wake. Additionally, the FHA and State Fair Housing Act used different terminology to define a physical or mental impairment that substantially limits one or more of a person's major life activity. Regardless of the terminology used, the definition of the terms remain the same. The terminology and definitions provided by the FHA and the State Fair Housing Act are: the Fair Housing Act defines disability as those individuals with mental or physical impairments that substantially limits one or more major life activities. The term mental or physical impairment may include conditions such as blindness, hearing impairment, mobility impairment, HIV infection, mental retardation, alcoholism, drug addiction, chronic fatigue, learning disability, head injury, or mental illness. The State Fair Housing Act defines handicapping condition as 1. A physical or mental impairment which substantially limits one or more of a person's major life activities. 2. A record of having such impairment. 3. Being regarded as having such an impairment. Handicapping conditions does not include current illegal use of or addiction to a controlled substance as defined in 21 U.S.C. 802, the Controlled Substance Act. The protections against discrimination on the basis of handicapping conditions shall apply to a buyer or renter of a dwelling, a person residing in or intending to reside in the dwelling after it is sold, rented, or made available, or any persons associated with the buyer or renter. Under federal and state fair housing laws, if an individual has a disability handicapping condition which substantially limits the major life activities such as learning, walking, seeing, and breathing, the individual may request a reasonable accommodation to occupy and use the dwelling. Handicapping conditions and disability. As you can see here, we have a list of people and what their disability is. Notice you can't tell on some of these people that they have a disability. What is a reasonable accommodation? A reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with a disability to have equal opportunity to use and enjoy a dwelling, including public and common use spaces. It is not necessary for an individual to submit a written request or use the words reasonable accommodation, assistance animal, or any other special word to request a reasonable accommodation under FHA. However, the person making the request is encouraged to do so in order to avoid miscommunication. The request for reasonable accommodation for an assistance animal may be: the request for a reasonable accommodation for an assistance animal may be oral or written and requested by others on behalf of the individual, including a person legally residing in the unit with the requesting individual, a legal guardian, or an authorized representative. In addition, an individual may also want to keep a copy of a reasonable accommodation request and supporting documentation in case there is a dispute regarding the validity of the request later. An individual may request an accommodation in order to use or occupy a dwelling either before or after acquiring the assistance animal. Under FHA, a person with a disability may make a reasonable accommodation request at any time. The housing provider must consider the request even if the resident made the request after bringing the animal into the dwelling. A housing provider's failure to provide a reasonable accommodation is a violation of FHA and state fair housing laws. What is the difference between a service and an assistance animal? There are major differences in rules regarding accommodation requests related to animals. To determine which rule applies, you must first determine the type of property for which the accommodation request is being made. The American with Disabilities Act, ADA, applies to commercial properties, places of public accommodation. The ADA defines criteria for service animals. The FHA applies to residential properties. The FHA defines criteria for assistance animals. There are major differences in rules regarding animals. Which type of property will the animal be accessing? Commercial and public properties, you will apply the ADA service animal. If it's residential units, you will apply the FHA assistance animals. Fair Housing Act, assistance animals. The FHA makes it unlawful for a housing provider to refuse a reasonable accommodation for a person with a disability who needs it to use and enjoy the dwelling. Therefore, housing providers are required to modify or make exceptions to policies when it may be necessary to permit persons with disabilities to have an assistance animal. On January 28, 2020, HUD issued Fair Housing and Equal Opportunity Notice FHEO-2020-01, which states in relevant part, this notice explains certain obligations of housing providers under the Fair Housing Act with respect to animals that individuals with disabilities may request as reasonable accommodations. There are two types of assistance animals: service animals and other trained or untrained animals that do work, perform tasks, provide assistance, and or provide therapeutic emotional support for individuals with disabilities, referred to in this guidance as a support animal. Policies including pet deposits, fees, and or breed restrictions do not apply to assistance or service animals because these animals are not considered pets. A housing provider may charge a fee or deposit for pets. Here's the link to the entire FHEO notice, FHEO-2020-01, issued by HUD. Remember, an assistance animal that does not qualify as a service animal or other type of assistance animal is a pet for purpose of the FHA and may be treated as a pet for purposes of lease and housing providers' rules and policies. Definitions and guidelines under Fair Housing Act, FHA. Assistance animals, i.e. support animals, work, perform tasks, provide assistance, or provide emotional support for a person with a physical or mental impairment that substantially limits at least one major life activity or bodily function. According to the FHEO notice, FHEO-2020-01, issued by HUD, housing providers may use the following questions as a guide to help them make a decision regarding a reasonable accommodation request. The Fair Housing Assistance Animal Decision Tree. Here is just a quick guide to show you based upon your answers. We're going to go through these answers real quick. Number 1, has the individual requested a reasonable accommodation to get or keep an animal in connection with a physical or mental impairment or disability? If yes, you're going to proceed to question 2. If no, the housing provider is not required to grant a reasonable accommodation if the purpose is not related to a handicapping condition or disability. Number 2, does the individual have an observable disability, or does the housing provider or agent making the determination for the housing provider already have information giving them reason to believe that the person has a disability? If yes, you're going to proceed to question 4. If no, proceed to question 3. Note, observable disabilities including blindness or low vision, deafness or being hard of hearing, mental illness or mobility limitations. Some impairments may not be observable. In such case, the housing provider may request information regarding the disability and the disability-related need for the animal, but is not entitled to know the individual's diagnosis. 3, has the individual requesting the accommodation provided information that the that reasonably supports the individual seeking the accommodation has a disability? Yes. Proceed to question 4. No, the housing provider is not required to grant the accommodation unless this information is provided. Note that the housing provider must provide the individual with a reasonable opportunity to submit the information. Information about the disability may include a determination of a disability from a federal, state, or local government, a receipt of disability benefits, eligibility of a housing voucher due to disability, or information confirming a disability from a healthcare professional. Before denying a reasonable accommodation request due to lack of information, the housing provider is encouraged to engage in a good faith dialogue with the requesting party called the interactive process. The housing provider may not insist on specific types of evidence if the information which is provided or actually known to the housing provider meets the requirements. Also, a housing provider may not request the disclosure of the diagnosis, severity of the disability, or medical records examination. Remember, an attorney should be consulted before denying a reasonable accommodation request to prevent violations of the Fair Housing Act. Also, the NC Human Relations Commission is a resource for brokers and housing providers regarding fair housing questions and concerns. This agency can provide information regarding reasonable accommodation requests and when they can be denied. Also, it is recommended that individuals seeking reasonable accommodations for support animals ask health care professionals to provide the following statement certifications. The patient has a physical or mental impairment. The patient's impairment substantially limits at least one major life activity or major bodily function, and the patient needs the animal because it does work, provides assistance, performs at least one task that benefits the patient because of his or her disability, or because it provides therapeutic emotional support to alleviate a symptom or effect of the disability of the patient. Some certificates and licensing documents can be obtained via the internet for a nominal fee. According to FHEO Notice FHEO-2020-01, documentation from the internet is not, by itself, sufficient to reliably establish an individual has a non-observable disability or disability-related need for the assistance animal. 4. Has the individual requested the accommodation provided information which reasonably supports that the animal does work, performs tasks, provides assistance, and or provides therapeutic emotional support with respect to the individual's disability? Yes, you're going to proceed to question 5. No, the housing provider is not required to grant the accommodation unless this information is provided, but may not deny the accommodation on the grounds that the individual has not provided the information until the housing provider has provided a reasonably opportunity to do so. 5. Is the animal commonly kept in households? Yes, the reasonable accommodation should be provided. No, animal is a reptile, barnyard animal, monkey, kangaroo, or other non-domesticated animal. A reasonable accommodation should not be provided unless the individual demonstrates a disability-related therapeutic need for this specific animal. The individual is encouraged to submit documentation from a healthcare professional confirming the need for the animal. Unique animals may be a reasonable accommodation if the animal is trained to do work or perform tasks that a dog cannot perform and the information from the healthcare professional confirms. The individual has allergies that prevents using a dog, or without the animal, the symptoms or effects of the person's disability will be significantly increased. It may be helpful for patients to ask healthcare professionals to provide the following additional information: the date of the last consultation with the patient, any unique circumstances justifying the patient's need for the particular animal, if already owned or identified by the individual, and whether the healthcare professional has reliable information about the specific animal or whether they specifically recommend this type of animal. Example, a Capuchin monkey is trained to assist a person with a spinal cord injury who has paralysis. The monkey, because it has hands, can retrieve a bottle of water from the refrigerator, unscrew a cap, insert a straw, or place the bottle of water in the holder for the individual. A service dog is not able to perform these types of manual tasks. Although domesticated, non-domesticated, and unique animals may be considered for reasonable accommodation, a housing provider may deny a reasonable accommodation request due to a direct threat to the health and safety of others, or the potential of the animal to cause substantial physical damage to the property of others. Reasonable accommodation requests must be analyzed using objective evidence about the particular conduct of the assistance animal and not the conduct of similar animals. Americans with Disabilities Act, FHA, service animals. The American with Disabilities Act, hereafter referred to as ADA, defines a service animal as any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or mental disability. The work or task performed by a service animal must be directly related to the individual's disability. Although a miniature horse is not considered a service animal under ADA, HUD and the Department of Justice, hereafter known as DOJ, issues guidance for animals that are not commonly kept in the household or unique animals. These types of animals are called assistance animals. Miniature horses are considered assistance animals if they are animals they do work, perform tasks, and provide assistance or emotional support for a person with a physical or mental impairment that substantially limits at least one major life or bodily function. According to the FHEO notice, FHEO-2020-01, housing providers may use the following questions as a guide to help determine if the animal is a service animal under ADA. One, is the animal a dog? Yes. Proceed to question 2. No, the animal is not a service animal but may be another type of assistance animal for which a reasonable accommodation is needed under FHA. Proceed to question 1 under the questions for a reasonable accommodation under FHA. 2. Is it readily apparent that the dog is trained to do work or perform tasks for the benefit of an individual with a disability? Yes. Additional inquiries are unnecessary and inappropriate because the animal is a service animal. No. Proceed to question 3. 3. Is the animal required because of a disability, and what work or task has the animal been trained to perform? Yes. If the animal is required because of a disability and the work or task is identified, then the reasonable accommodation should be granted because the animal is a service animal. No or none. If the animal is not required because of the disability, the animal does not qualify as a service animal under ADA, but may be a support or other type of assistance animal that needs to be accommodated under FHA. Performing a work or task means that the dog is trained to take a specific action when needed to assist the person with a disability. Some examples of the disability support functions service animals perform are alerting a hearing impaired person to sounds, guiding a visually impaired person, pulling a wheelchair, or reminding a person to take their medication. Moreover, policies including pet deposits, fees, and/or breed restrictions do not apply to service animals because they are not considered pets. I am a broker managing a property on behalf of an owner. My tenant has submitted an accommodation request. What is the correct process? Brokers should educate their owners on fair housing laws and the difference between pets, service animals, and assistance animals before providing property management representation. If a tenant is requesting an accommodation for an assistance or service animals, brokers may request on behalf of their owner documentation to support the existence of a disability or need for the animal if not readily apparent. Lastly, brokers may provide a response to a tenant's accommodation request for an assistance or service animal after speaking with the owner. If a broker receives a request for a reasonable modification to the property, the broker must communicate the request to the owner. The owner will then decide whether or not the request is reasonable. However, the broker may request on behalf of the owner documentation to support the request for the reasonable modification. Additionally, brokers and owners must ensure that they are complying with fair housing laws when responding to an accommodation request. Further, they have the burden of proof to demonstrate a legitimate basis for denying a reasonable accommodation request. Most importantly, a failure on the part of the broker or owner to respond is in itself a violation of FHA. When can a request for a reasonable accommodation be legally denied? A reasonable accommodation request may be legally denied if the accommodation will cause an undue financial and administrative burden on the housing provider. Accommodating the request will fundamentally alter the housing provider's service. The assistance animal poses a direct threat to the health and safety of others that cannot be reduced or eliminated by another reasonable accommodation, or an assistance animal causes substantial physical damage to the property of others that cannot be reduced or eliminated by another reasonable accommodation. An attorney should be consulted before denying a reasonable accommodation request to prevent violations of the Fair Housing Act. Also, the NC Human Relations Commission is a resource for brokers and housing providers regarding fair housing questions and concerns. This agency can provide information regarding a reasonable accommodation request and when they can be denied. The North Carolina Real Estate Commission has published a brochure entitled Fair Housing to assist brokers and housing providers with the Fair Housing Act. It is available at www.ncrec.gov. Examples of accommodations. The following are examples of accommodations a housing provider may provide an individual with a disability handicapping condition. Assigning a reserved parking space for one individual, even though no other individuals have assigned spaces. Provided written material orally in large print or braille. Providing reminders for a developmentally challenged individual when lease payments are due. Permitting a live-in aid with a disabled individual when it violates normal occupancy policies, and permitting service animals when the policies otherwise prohibit pets. An example of failing to provide a reasonable accommodation occurred in Castillo Condo Association versus U.S. Department of Housing and Urban Development, 821 F.3D 92. In this case, Carlo Jimenez Bianco resided in a condo governed by the Castillo Condominium Association, hereafter known as the Association. The association learned that Jimenez had a dog in his condo which was in violation of the no pets policy and sent him a letter. Jimenez promptly responded with a letter from his treating psychiatrist asserting the disability-related need for his emotional support dog. The association failed to provide the reasonable accommodation after the response, and this led Jimenez to sell his condo that he occupied for 15 years. Jimenez filed a complaint with HUD, and after a thorough investigation, HUD lodged a complaint against the association. Initially, after a 4-day evidentiary hearing, an administrative law judge ruled that the association did not violate the Fair Housing Act because Jimenez did not provide that he had a mental impairment. This decision was appealed to the Secretary of HUD, and the Secretary found that the association was in violation of the Fair Housing Act due to the following facts. Jimenez had a recognizable disability. Jimenez informed the association of his need for the reasonable accommodation, and the association denied the accommodation request and failed to engage with Jimenez in an interactive process. The Secretary awarded Jimenez damages for the emotional distress, assessed a civil penalty against the association, and implemented mandatory training in fair housing for the officers of the association. The association appealed to the court. The court upheld the findings of the Secretary of HUD and stated in its ruling that the association knew or should have known of the disability, and the emotional support dog was a reasonable accommodation that would have afforded Jimenez an opportunity to use and enjoy his dwelling. Furthermore, the court held that the actions of the condominium association violated FHA and affirmed that the housing providers must modify or make exceptions to a no pets policy for persons with disabilities who require service or assistance animals. The National Associations of Realtors have provided a video, Window to the Law, Assistance Animals in Housing, indicating the criteria housing providers can use when considering a request for accommodation under FHA. Here's the link for the video. Reasonable accommodation requests for service animals in places of public accommodation. There are similarities and differences between the FHA and ADA. One similarity is that they both prohibit discrimination against a protected class of individuals. However, they are distinguished by the FHA prohibiting discrimination and providing equal access to housing for protected classes, and the ADA prohibiting discrimination in the use and enjoyment of places of public accommodation for protected classes of individuals. According to the ADA Title III regulations, a place of public accommodation means a facility operated by a private entity whose operations affect commerce and falls within at least one of the following categories: places of lodging, restaurant or bar, theater, places of public gatherings, grocery, like retail stores, laundromats, public transportation, places of public recreation, places of education, social centers, establishments like daycare, senior citizens, and places of exercise or recreation. Under the ADA, if an individual is requesting an accommodation be made for a service animal in a place of public accommodation, the owner, manager, may not ask questions about the existence or nature of the individual's disability. However, the following questions may be asked to determine whether the animal is a service animal. Is the service animal required because of a disability? What work or task has the animal been trained to perform? Can the owner require the individual to provide documentation regarding the service animal's certification or training? No. Asking the individual to provide proof of the animal's certification is not permitted. The owner, manager may only ask the two questions mentioned above, even if the disability is not known or the task and/or work performed by the animal is not readily apparent or known. What if the task or services provided by the animal are readily apparent? Can the owner ask for more information? No. Can a service animal be legally denied access? A service animal can be legally denied access to a place of public accommodation only if the animal is out of control and the handler is not effective in controlling it, the animal is not housebroken, or admitting the service animal would fundamentally alter the nature of the goods, services, programs, or activities provided to the public. Example, inability to go to certain areas within a zoo due to causing agitation of animals. Complaints. How? Where are they filed? In North Carolina, complaints for alleged violations of fair housing laws must be filed within 1 year of the alleged violation with the North Carolina Human Relations Commission at 1711 New Hope Church Road, Raleigh, North Carolina. Once a complaint has been filed, the NCHRC will investigate to determine whether unlawful discrimination has occurred and attempt to eliminate discriminatory practices by having an informal conference, persuasion, or conciliation, or issue a right to sue letter if allegations of discrimination are not determined. If a resolution cannot be achieved by NCHRC, an individual may request a right to sue letter so that they may file a civil lawsuit, allow NCHRC to file a lawsuit for them, or have an administrative hearing to determine a final decision on the matter. An individual may choose to file a civil lawsuit at their expense without filing a complaint with the NCHRC at any time. A civil lawsuit must be filed within 1 year of an alleged violation of the state fair housing laws and within 2 years of the federal fair housing laws. Additionally, a complaint can be filed with HUD's Fair Housing Equal Opportunity Housing Office using the following options: in English or Spanish online at www.hud.gov, download a HUD complaint form in a variety of languages and email it to the local FHEO office, call an FHEO intake specialist at 1-800-6 669-9777 or your local FHEO office. Penalties. The U.S. Department of Housing and Urban Development, HUD, published adjusted civil penalty amounts on May 15, 2019 for individuals and entities that have been found in violation of housing-related laws after April 15, 2019. The maximum civil penalty is $21,039 for the first violation of FHA. The civil penalty is $10,000 for the State Fair Housing Act. If an entity or individual has violated the Act within the previous 5 years, a maximum fine of $52,596 may be awarded under FHA and $25,000 under the state. Consequently, if a violation has occurred 2 or more times within the previous 7 years, a maximum fine of $105,194 is awarded for FHA violations and $50,000 for state violations. Civil penalty amounts are in addition to any award for actual damages, attorney fees, and/or cash due to housing discrimination. Can real estate brokers be held liable for their clients' or employees' fair housing violations? Yes, FHA pertains to all individuals who are engaging in residential real estate transactions, so brokers may be liable for their clients' or employees' violations of FHA, even if the brokers did not directly discriminate. In an effort to prevent fair housing violations, brokers should educate their clients on fair housing laws before providing brokerage services. Most importantly, in order for a broker to educate their clients' employees, they must first obtain knowledge by attending training and educational programs. I am a broker managing a property on behalf of an owner. My owner client does not want me to rent the property to families with young children because the back deck is very high off the ground. If I follow the owner's directive, can I get in trouble? Yes. FHA prohibits discrimination based on the protected class of familial status, which means families with children under the age of 18. A broker may not legally exclude a protected class member at the directive of an owner, regardless of the reasoning behind it. Also, if the broker knows that an owner unlawfully discriminates against a tenant or applicant, then the broker too is in violation of the Fair Housing Act. I am a broker managing a property on behalf of an owner. I have explained that service animals must be permitted under the law, but the owner refuses, saying no animals will be allowed. What can I do? If you proceed with this client, you too can be held liable for violations of the Fair Housing. Also, you will be in violations of license laws and commission rules. If the client will not relent, you should terminate the agency agreement immediately in writing and explain the reason for the termination. Will my firm be liable if one of the employees or affiliated brokers discriminates against a protected class member? Yes. The firm will be liable for the actions of affiliated brokers and employees if unlawfully discrimination against a protected class member occurs. The firm will be liable due to vicarious liability. Vicarious liability is when an employer is held responsible for the neglect of an employee or affiliate while they are performing a work-related task. One such violation occurred in the case of Chicago versus Matchmaker Real Estate Sales Center, Incorporated, 982 F.2 D 1086 in 1992. In this case, the Leadership Council in Chicago suspected that the defendant, agents of Matchmaker Real Estate Sales Center Incorporated, were engaging in the illegal practice of racial steering. Therefore, the Leadership Council conducted a series of 5 tests intermittently from July 1987 until June of 1988. The testers, black and white individuals, posed as home seekers looking for properties on the southwest side of Chicago and nearby suburban areas. The Leadership Council ensured they met various financial qualifications, i.e. income and down payment availability, and had varying housing needs, i.e. family size and preference. During the test, black testers were only shown homes in the black areas of town, Chicago Lawn and Gabe Park. The white testers received computer lists of the homes available in the suburban areas. The CEO and sole shareholder holder of Matchmaker Real Estate Sales Center Incorporated, Erwin Ernest, had written office policies ensuring that agents complied with all fair housing laws and attended additional training courses sponsored by the local real estate board. However, during the bench trial, the magistrate judge held that Erwin Ernest and Matchmaker Real Estate Sales Center were vicariously liable for the actions of his agent, even though he was unaware of any discriminatory conduct. The judge replied on the following to support his findings. A principal cannot free itself of liability by delegating to an agent the duty not to discriminate. Ernest also argued that the agents were considered independent contractors via the employment agreement. The judge threw out the argument that agents were independent contractors because the agent worked in Matchmaker's office until Ernest's day-to-day control and supervision and followed multiple office policies while conducting real estate transactions. The magistrate judge held that the agents violated the Civil Rights Act of 1866 and the Fair Housing Act. Additionally, the judge agreed to hold Ernest and Matchmaker Real Estate Sales Center vicariously liable for the unlawful behavior of its agents. In addition, the court said, as a matter of well-settled agency law, a principal may be held liable for the discriminatory acts of his agents if such acts are within the scope of the agent's apparent authority, even if the principal neither authorized nor ratified the acts. Also, all defendants were jointly and severely liable for punitive and compensatory damages and a monetary award for frustration of purpose. The following cases also supported the court's opinion that an employer is vicariously liable for the acts of their agents or employees while they are acting within the course and scope of employment. And here are two cases that you can look up if you need to. If I violate fair housing laws, can I lose my broker's license? A violation of the fair housing law is also violation of the NC General Statute 93A-6, A10 and 15, and Commission Rules 58A.1601.